Decision. If two people have a child together or adopt a child and then decide to live separate lives, the parents will have to decide how much time the child will spend living with each parent and how the parents will share and divide their parental responsibilities. Types of custody. There are two types of custody, legal and physical. Legal custody means the parent or party with the right and responsibility to make the decisions relating to the health, education, and welfare of the child. 2. Physical custody means the parent or party the child lives with the most of the time. Attention! The legal and physical custody of a child may be sole or joint. Joint custody. Joint legal means that both parents have joint legal and joint physical custody of their children. Sole or joint legal custody. Sole legal custody means that one parent or party will have the right and responsibility to make all decisions relating to the health, education, and welfare of the child without asking permission or conferring with the other parent. Joint legal custody means that both parents will share the right and responsibility to make the decisions relating to the health, education, and welfare of the child. Attention! In an emergency, either parent, of course, can make decisions if he or she has to do so. Sole or joint physical custody. Sole physical custody means the child will live with one of the parents or parties and be under the supervision of that parent or party. The court may order that the other parent have some rights of visitation to the child. Joint physical custody means that the child will spend a significant amount of time with each parent. Joint physical custody tries to be as close to 50-50 as possible. Joint physical custody with primary residence to one parent means that the child spends considerable amount of time with both parents, but sleeps at the residence of the parent with primary residence. Make your own deal. You know or should know what is the best custodial arrangement for your children with the other parent. If you're still on speaking terms with the other parent, have a civil conversation with the other parent and try to work out the best custodial plan for your children. Third-party assistance. If you are having problems reaching an agreement with the other parent, enlist the help of someone you both trust. This person might be a mutual friend, your minister, your rabbi, your priest, and or a therapist you both trust who specializes in custodial arrangements. The court system. If the parents cannot work out what is the best custodial arrangement or schedule for their children, the parents will have no other option but to go through the family court system. Family law cases in which a parent can ask for child custody orders. Types of family law cases in which a parent can ask for a child custody order is as follows. 1. Divorce, legal separation, or annulment. 2. Domestic violence restraining order. And 3. Parentage, also known as paternity case. The family law court system. There are two key public policies that guide the family law judge's decision regarding custody. Namely, 1. Best interest of the child, also known by its acronym BIC, and 2. Frequent and continuing contact with each parent. If the two policies are in conflict because of the particular circumstances of the case, the best interest of the child prevails. Factors considered within the best interest of the child policy, also known as BIC. The factors that the family law court judge will look at in determining the best interest of the children includes the following. 1. The health, safety, and welfare of the children. 2. Any history of abuse by any party seeking custody. The takeaways. When two parents separate, they need to come up with a plan to share the children. Try to work out an arrangement with the other parent instead of letting a family law judge have to make the decision for you. If you have no choice but to go through the court system, the family law judge will use two policies known as 1. The best interest of the child, and 2. Frequent and continuing contact with both parents as a guide in helping him or her decide custody. Depending on the facts of the case, the arrangement can range from joint legal and joint physical, where both parents share equal rights and time with the child, to sole legal and sole physical, awarded to one parent with limited visitation to the other parent.